So keep talking about your... Oh, there we go. Hi, so I think the recording's going, so we'll start. So my name's Nick Williams. I'm the Policy and Campaigns Officer at Index on Censorship, which is one of the co-chairing organisations of the UK Anti-SLAPP Coalition. Thanks, everyone, for joining us for this panel, which I think will be really, really exciting to look at the wide breadth and the depth and the complexity of SLAPPs. The sort of ghost at the feast this whole 2 days has been the Economic Crime and Corporate Transparency Act, which was passed last month, that brought in limited but welcome anti-SLAPP provisions for reporting on economic crime. We are, cognizant of the fact that this is one of the first of its kind in Europe, and it will offer meaningful protections against SLAPP's targeted economic crime. However, we do know that there are limitations. It is only for economic crime, and it does include a complex, time-intensive, challenging process of trying to derive the belief of the claimant to decide whether it is a SLAPP. But it is a step in the right direction. And the UK government, to their credit, has acknowledged this as a step and not the realization of their commitment they made in July 2022. We are yet to see any more meaningful anti-SLAPP laws in England and Wales, but hopefully this can be the start of something. But when we've been talking about this in the coalition, we know it is not just economic crime. And the last session with Tom, while he has reported on economic crime and corruption and things like that, the allegations that he was reporting on, the allegations that formed the basis of the legal action against him by ENRC, arguably were not that of economic crime, it was that of allegations of suspicious deaths. So whether that would even protected Tom if it was in power then is an open question. So this panel will start probing beyond economic crime to sort of look at how SLAPPs poison the entire groundwater for freedom of expression and public participation. And tonight we also have Nina Cresswell, who will speak incredibly powerfully about her fight against a defamation threat because she named her the person who assaulted her. But we've got some amazing panelists. You're not going to hear too much from me because you're here to see them, I'm very aware. So I'm just going to introduce people and then give them some time to talk about their work and their background, and then we can move on from there. So first, to my direct left, is Peter Apps, who's a contributing editor for Inside Housing, and he's an author. He's recently published Show Me the Bodies, How We Let Grenfell Happen, which recently won the Orwell Prize. Next to him is Don Staniford, who's the director of Camon Scotland and the Real Salmon Farming Resistance. And he is an extreme activist, that is in the biography, that's not me editorializing, who has campaigned against toxic salmon farms for 25 years. He's currently the director of Camon Scotland and global director of the Real Salmon Farming Resistance. He's an award-winning campaigner and author. In 2002, he was awarded the Andrew Lees Memorial Award at the British Environment and Media Awards. In 2005, he won the Roderick Haig Brown BC Book Prize for A Stain Upon the Sea, West Coast Salmon Farming, which was co-authored by Alexandra Morton, Stephen Hume, Otto Langer, Betty Keller, and Rosella Leslie. And joining us online, hopefully, is Saba, who is a solicitor at Media Defence. Saba qualified as a solicitor in 2013 and joined Media Defence in 2018. She previously practiced in the areas of criminal defence, extradition, and civil litigation. And prior to that, Saba worked on cases involving international human rights law and public law, as well as litigating and advocating on various criminal defence and extradition cases before courts in the UK. She has interned with Reprieve, assisting in their death penalty work in the MENA region. And she holds a BSc and LLB and is fluent in Urdu and conversational in Arabic. And to my far left is Elise Perry, the legal manager for media freedom at Thomson Reuters Foundation, where she manages the legal support options available for journalists and media organizations as the legal manager for media freedoms at the Thomson Reuters Foundation. Prior to joining in 2021, Elise was a global justice scholar at New York University and a consultant for the UN Development Programme, building collaboration between UN agencies working on the rule of law projects. Elise is a qualified lawyer in Australia, and she has a Bachelor's of Law and Bachelor's of Art from the Australian National University and the Masters of International Law from New York University. So this is my exceptionally expert panel, which I'm really honoured to be on the platform with. So I think I'm going to start off with Peter. I mean, you've worked extensively reporting on housing and the broader conversations, the broader sort of housing space. Obviously, you're reporting on the tragic fire at Grenfell, but also the broader conversation around that and what steps led to that happening, but also the broader industry. So I'm going to give the floor to you, just sort of to sort of talk about this space and how this is relevant within the SLAPP context.
Yeah, sure. Okay, thank you, Nick, and thank you everyone for coming to listen to us on this. But what's a really important topic to all journalists, I think, and anyone else who wants to use their right to freedom of expression to talk about things that people might not want them to. So most of you may not have heard of Inside Housing. We're quite a small fish in the UK media landscape. We're what's known as a trade publication, so we're read primarily by people who work in an industry, this one being social housing. I've also worked in the local media for a few years, and I think sometimes the kind of high-profile libel cases and the things that you hear about in conversations like this would lead you to believe you wouldn't have too much to worry about at smaller organisations like the ones I've worked for. But that couldn't be further from the truth. Any journalist at any level in the UK has to worry about libel law. It has to be one of the first things you think about when you're putting a story together and making the decision as an editor whether or not to publish it. So just to kind of explain how that works typically for people like me, you're obliged, not by law, but by kind of editorial process and in order to have any kind of functioning libel defence, to give the person you're writing about the right to respond to the allegations that you're going to make in any article, and a reasonable length of time to respond to them as well. So what will happen is, for certain organisations, you will approach them for that right of reply, give them, say, 24 hours or 48 hours to come back, and rather than getting a statement for use in your article, you get a letter from their legal team telling you that they will sue the publication and sue you in a personal capacity if these inaccurate and defamatory statements ever make it into the public domain. And then as an editor and as an editorial team, you have to decide whether you're going to publish in the face of that threat or not. Sometimes it's a kind of sort of sneaky level below that, where they won't overtly say that they're going to sue you for libel, but they will say something like, we believe that these statements are damaging to our commercial reputation, and we would not hesitate to take action if they did damage it. So you haven't quite got a legal letter which you could send to the Solicitors Regulation Authority, but you do have a pretty clear understanding of what's going to happen if you press live on your story. Just some of the sorts of organisations that we've had that interaction with. There's a consultant who's written fire safety advice for the Home Office for years, whose prior behaviour and comments I was not even going to criticise. I was just going to highlight. We got several slaps from him and his lawyers. There was a new investment fund which was moving into the social housing space, but it was going to be providing homes for people with severe mental health issues and physical disabilities. But it was going to be doing that whilst paying its shareholders a profit margin of between 8 and 12%. And we believe that there were some quite serious conflicts of interest in how that business was being set up. And again, the right of reply to that story resulted in a very, very, very strongly worded slap. That's the most difficult one we've had to deal with in my career. And then also just a straightforward, for want of a better word, rogue landlord, someone who had a block of flats with very serious water ingress problems that were causing health issues for the residents who lived there. I think I had a letter from a medical charity which said that I think 15 children were on inhalers living in this block directly as a result of the conditions they were in. The local authority had deemed it a Category 1 hazard. Of those stories, one of the three, well, two of the three were published. One of them never was. The one of the ones that was published, we only managed to publish because we were able to get, a group of people were able to get a peer to repeat the allegations in the House of Lords first, and then we reported on that. I think a lot of the time, the conversation about how this space works is led by journalists who work at publications where they have in-house legal teams, and it's a completely different game if you don't have that. I've had access to legal advice at every publication I've worked for. That's not true for quite a lot of them, but the access is paying for a solicitor with a limited budget and being aware that if you're going to have to fight a case, you're going to have a conversation with your insurers. You're going to have to think about the sort of bandwidth you have editorially among senior members of the editorial team to make those decisions, to get the notes together, to fight a case. We're not really in a position to use things like public interest defences and even, sort of straightforward justification defences. We need quick answers to these issues to make them go away fast enough that our small team with our small legal budgets can hope to fight. And if we can't get that, even though we're getting legal advice that might be you'll win this case, we still won't run the story. That's just the reality for small fish in the media environment. And I think one of the other things I want to stress before I hand on to the other panelists is that it's often journalists that talk on panels like this and lead these conversations. I'm pleased that we've got an activist on the panel today because it's very much not just journalists who face these sorts of legal threats. Just to give a couple of examples, Nick mentioned in the introduction that I wrote a book about the Grenfell Tower fire. The residents of Grenfell Tower were publicising the conditions that were present in the tower in the years building up to it, and they faced legal action from KCTMO. They were warned that what they were writing was defamatory and they could be sued for it. The Lambeth Council's recently been in the news for using non-disclosure agreements when it settles cases with leaseholders so that other leaseholders don't find out that a settlement's been made and also make the same claim. I've heard individual tenants complain to their landlord and be threatened with libel, both in the private and social sectors. I've heard tenancy agreements even being used to attempt to gag people. They're saying, talking about this is a breach of your tenancy agreement. It's not libel law, but it's still a way of preventing someone expressing themselves freely. And even in one instance, and I haven't stood this up, but it came from a source who I believe to be telling the truth, that a council's environmental health team trying to find that, put an enforcement notice on a landlord for renting property in poor condition was threatened with libel action by that landlord. And finally, in the Grenfell Tower inquiry, it emerged that Kingspan, one of the companies which sold combustible insulation products, which ultimately ended up on the outside of the building, I won't get into all of the technical detail of this, but a large building control organisation which signs off most of the UK's high-rise projects, had decided that Kingspan was not suitable for high-rise buildings, didn't meet our building regulations, and shouldn't be allowed going forward. And they were going to put out a notification to all of their inspectors saying, please stop signing off projects with Kingspan in it. And the immediate response of Kingspan was not to fight that through construction law, but to fight it through libel law. It's the part of the public paper trail now in the inquiry was a libel letter warning them of serious commercial consequences. So at every level of civil society, activists, journalists, local authority enforcement teams, even the National House Building Council, this is a problem. And if we're going to address SLAPPs, and we need to make the solution something that works for all of those groups. So yeah, that's all I've got to say.
Thank you, Peter. And I mean, that really sort of shows the scale, but also almost the sort of the creativity of those trying to seek to shut down. Weaponizing strong journalistic practice, such as right of reply, emails ahead of time, but using that as a gateway through to legal threats, as well as you say, NDAs, tenancy agreements. I've seen some of the correspondence aimed at the Grenfell residents. And the idea, in the UK, including Scotland now, you can't, public bodies cannot bring defamation actions because of the Derbyshire principle. But these letters were set and signed by the senior lawyer for the council, the local council. And my gut feeling is that's because they banked on the residents not knowing that public bodies can't bring legal action. So it was the threat, and I think they knew it couldn't go any further, but the threat was enough. But I think housing, we've seen a number of cases, and it is a really challenging and complex space where there are a lot of people who will be using these means to try and shut down scrutiny. Obviously, we've been talking about the ECCT. It's only enforced in England and Wales. It's not relevant for Northern Ireland and Scotland. And a lot of the conversations around SLAPPs has been centred on England and Wales. Obviously, London, town named Sue. There is a fledgling conversation in Scotland. I am going to shamelessly plug a conference we're organising on the 26th of February on that very topic. But it's also something that we're looking at in terms of ensuring that jurisdiction is protected against legal action. And that's why I'm really honoured to have Don here, who's experienced, I would say, a quite a unique SLAPP within both, in Scotland and the UK, the use of injunctions or interdicts in Scots law lingo. I will say he is currently in the midst of a number of legal threats, so there will be stuff that he can't say. But Don, I'm happy to pass on to you to talk about your work.
Thank you very much. And yeah, please come to the conference in Scotland in February. Thanks to Index and Censorship in particular, and to Susan everyone for the invitation. Mine's a SLAPP suit on the water. As Nick said, I'm in the eye of a SLAPP storm at the moment, so there's certain things I can't talk about. I'll give a wave to any lawyers from the Sal Mafia that may be watching. I think I'll talk about the negative aspects of SLAPP suits, the intimidation, the isolation that we talked about yesterday, but I'll also try and end on some positive notes. I don't think Tom's here, but one of my favourite poems, Stephen Spender, who founded Index on Censorship, the word bites like a fish. So censorship and fish go together. You may be a Monty Python fan. If you Google Monty Python, the fish slapping dance, you'll see Michael Palin slapping John Cleese with a little small pilchard in the face. And it goes on for about 10 seconds. It's only 20 seconds on Google if you want to Google it. And then John Cleese gets a big salmon out behind his pocket and slaps him into the water. Now, I'm not sure which end of that, whether I'm Michael Palin or John Cleese, but some of this will come out in the wash. I'll just say a little bit about where I came from and what I do and what's going to happen. I've campaigned against salmon farms for 25 years. Started with Friends of the Earth Scotland. I've campaigned in Norway and Canada. I've been to Chile and New Zealand, Australia. So everywhere that salmon farms operate, I call them the Sal Mafia. And I've got into the strange underworld of murky finance. And as an activist, primarily as a environmental activist, 5 years ago I moved into animal rights activism with a camera, a GoPro camera on a stick, highly technical, 10-pound telescopic pole from B&Q. So you kayak out to a farm, stick the camera in the pen, and you can film inside the salmon farm, which is a battery factory system. So we've got gruesome footage, gruesome video evidence inside some of the companies that are now suing me. So they're effectively trying to silence criticism, and they're trying to stop the truth coming out about what goes on inside their operations. So in 2017, in terms of Scotland, I was in a SLAPP suit in Canada, which seems to be a bit more advanced than the UK in terms of SLAPPs and anti-SLAPP legislation. 2017, I was threatened by Maui, which is owned by John Fredrickson, There's a biography in Norwegian about him called Storulv, the big wolf. I think he's the big bad wolf. He's worth 14 billion. I just looked on Forbes this morning. 127th richest man or woman in the world. If you cycle down past Embankment and Chelsea, you'll see his house, a £100 million house that Roman Abramovich tried to buy in Chelsea. So he's the owner of that company that sued me in 2021. They forced me into an undertaking, which is effectively an interdict and injunction. So I'm prohibited for the last 2 years from going near 15 meters near their farms, so I can't film inside 40 or so salmon farms on the west coast of Scotland. There's maybe about 200 salmon farms. And then I lost the case in August and it's on appeal. I appealed in October, so without my lawyers, and I've got an amazing legal team in Scotland and legal assistance. Without that, I'd be kind of dead in the water. In October, a second Norwegian multinational piled in a similar injunction, interdict. So I'm now prohibited for going from maybe half the industry. And then on Thursday, another one, Bakkafrost, which is owned by the Norwegian government, the largest shareholder based in the Faroes, jumped on. So I've got until the 1st of December, which is Friday, to decide whether I cave into that injunction undertaking. So I operate in the murky waters really between activism and journalism. A lot of my stories, a lot of my footage gets given to newspapers. I went to a land-based salmon farm, climbed a skip full of dead salmon. You can see some of the photographs on the slide with Netflix. You can watch that on Netflix's Seaspiracy. I helped the Kate Winslet narrated documentary Eating Away to Extinction. French TV have been on farms. So it's in the public interest, I would argue, what we do. We're trying to shine a light on welfare abuse, salmon farmers breaking the law. And then just to wrap up in terms of positives, I just throw in there also, I was... the Channel 4 News 2020 ran a story about environmental campaigners, activists being illegally surveillance by private investigator. I also got rung up by a Sunday newspaper last year that I was hacked along with Michelle Platini and Philip Hammond and Chris Mason. So there's other kind of behind the scenes surveillance that the Sal Mafia do. If I do write a book, it's either going to be called Sal Mafia, Sal Mobsters, Sal Monsters, Sal Money, or Sal Monopoly. So they're the choices. I'd like to just say some positives. We need to harness the energy of SLAPP suits. I think there's a superheroes from Marvel who can harness the energy back and it goes further forward. But Newton's third law of motion is, for every action, there's an equal and opposite reaction. So I think, certainly some of the times I feel like a piñata being battered, or a straw man, or a wicker man. But sometimes activists, campaigners, journalists can be like lightning rods, and we've all seen the graphic of the little tiny fish swimming and shoaling together and attacking the big fish. So sometimes David does slay Goliath. And then in terms of public engagement, one of the chilling issues in my lawsuit, as in others, you can't talk about it. I've actually talked about it quite a lot because I've got quite a big gob. But I think it is, this conference is amazing to learn from people, to swap stories, to network. And just to throw out there at the end, the cheesy Gandhi quote, first they ignore us, then they laugh at us, then they fight us, and then we win. Just a food for thought.
Thank you so much, Don. And this does highlight an interesting element with the use of injunctions. We've talked at length about how slow SLAPPs are conventionally, and the slowness is by design to exhaust your financial resources, to strain relationships, to drain your ability to work on other things. Whereas injunctions and interdicts are very quick. They can at times be secured without the target being able to present a defense, so ex parte injunctions. So while the techniques are different, it sort of results in the same thing, which is that sort of curtailed civic space. And also, you see it, I live in Scotland, you see there's a lot of reporting on salmon farms. It's a huge industry in Scotland, and there is a lot of public interest reporting on it. And a lot of that reporting would be impossible without activists like Don and people who are able to scrutinize the behavior of these companies, as well as the gaps in regulation. So I think that's a really important part of this broader landscape of SLAPPs. That is not, especially not in Scotland, but it definitely wouldn't have been addressed by ECCT if it happened south of the border. I'm going to pass it on to Elise, but before I do, I am also going to give a punt for their amazing report, Weaponizing the Law: Attacks on Media Freedom. It's an incredibly informative analysis of the legal and extra-legal threats to journalism around the world, not just in the UK, but around the world, but really contextualizes where SLAPPs fit in it. And I think it's a really good mirror to the conversation we had last night with Rana, Sarah, and a number of the other speakers. So Elise, it'd be great if you could maybe sort of summarize the report and talk about what the findings have led you to.
Sure. Thanks very much, Nick, and thank you very much for the plug. It saves me from doing it as well. So yes, as Nick mentioned, the Thomson Reuters Foundation did publish a report early this year. It's called Weaponizing the Law: Attacks on Media Freedom. So you can see it at medialegalattacks.com. We co-authored this with the Tao Center for Digital Journalism in Columbia, or at Columbia University. And one of the main reasons for doing this was to do exactly what this kind of conference is trying to do, which is to build an evidence base for the scale of legal threats that are being faced by journalists and media outlets. So to do this, we brought together a number of media freedom experts. Some of them are have been at this conference, so we thank you for your contributions. But perhaps even more importantly, we brought together almost 500 alumni from the Thomson Reuters Foundation journalism trainings, and we sought their first-hand experiences as well. So before I turn to what the findings were in relation to SLAPPs, I think a really good starting point is the quite compelling statistic that we had from this, that nearly 50% of the journalists who were surveyed had experienced or were facing legal threats. These weren't just limited to SLAPPs, but I think a number of them could still be classed as SLAPPs. But these demonstrate both the sheer number of journalists who are facing this currently, and also the global scale. So these survey responses came from 106 countries as well. In terms of what we found in relation to SLAPPs, I'm talking to probably an active audience here, so perhaps some of these won't necessarily be new facts, but I think the true rate came from the number of case studies that we were able to demonstrate to represent some of these trends. So the first one being, of course, that this is global. A lot of the cases we've been looking at have been understandably in the UK, but important to premise, and I think very powerful to emphasize that this is beyond that. So it's traditionally associated with Europe and with the UK, where of course it's particularly acute. But we do have examples across the globe to demonstrate that this is a global issue, and of course strategies are being shared across jurisdictions, whether democracies and non-democracies alike. We did have a dedicated panel on the second key finding yesterday, which is in relation to costs. So I think we're all in agreement that the costs are clearly increasing as well. One of the reasons for this is that defamation laws are still the preferred tool for SLAPPs, and this correlated with a decrease in what was originally a positive trend, which was decriminalising defamation laws. In the early 2000s, we were seeing a lot of positive trends towards decriminalising defamation across the world, but this report found that in the recent decade, unfortunately, that trend has been reversing. With some common examples, Russia, Timor-Leste, Burkina Faso, and Japan, and many others. So of course, that decriminalising of defamation, the reversal of that, it led to an increase of SLAPPs as well. so returning to the kind of the costs, so we're seeing an increase in costs, which is it reiterated in this report, but equally the Legal Network for Journalists at Risk, which is a kind of coalition of media freedom organisations that provide legal support. We've been operating for over a year now, and whilst this isn't just limited to SLAPPs, it relates to any kind of legal threats that journalists are facing. We are seeing kind of significant requests for support to cover legal-related costs. So these kind of go far beyond what the individual mandates are of a lot of the media freedom organisations working in this space. So a clear need to kind of really pool resources and also increase resources available to cover those costs. But beyond the legal damages that we're seeing, and this point has already been made by Nick and by others, but it's also seeing an increase in the ancillary tools that are being used. So things like the temporary injunctions, which I think serve the purpose of the intention of the SLAPP. They kind of stifle any critical reporting. In addition, they're kind of very clear clubbing techniques of adding in surveillance methods as well. Part of the report, I think the value, as I mentioned, is bringing to life a lot of these key trends. So I was going to touch on a couple of the examples as well. And a kind of caveat in advance that this is a slightly depressing kind of shopping list of examples, but only to emphasise that each of these examples are kind of worthy of a separate speaker as well, and I really encourage you to learn more about each of these cases as well. Even though this panel is kind of economic cases and beyond, I think we can't escape some of the case examples being economic cases. So we had quite a few that came out in relation to India. So of course we heard from Rana last night, who's been facing money laundering and tax evasion charges. Also in India, we interviewed NewsClick, which is a popular news website, who have been facing at least 3 money laundering investigations. In China, a journalist, Shen Jian, has been clubbed with a variety of criminal charges based on operating an illegal business, coercive business trading, corruption, and even kind of picking quarrels and provoking trouble. Also examples were found for Nicaragua and Tanzania, and these were all in the kind of corruption and illegal business charges. One of the interviews that we have available on our website, and so I encourage you to have a look at the first-hand experiences from the news outlet, is from Poland's Gazeta Wyborcza, a very kind of clear example of SLAPPs and the power that they have. At the time that he was interviewed, they were facing at least 90 SLAPPs, and these were predominantly in relation to stories about the CEO of Poland's state-run oil giant. And these covered both kind of a suite of resources, of kind of articles that they produce, but also sometimes covered just kind of a single sentence in the story as well. And he talks very powerfully about the impact that this had, not just on the legal fees, but also the distraction it had from doing their reporting. In Serbia, we documented over 26 SLAPPs in the period of 2010 to 2020. Whilst these were across a number of activists, journalists and media outlets, they all came from one kind of politician and a linked businessman as well. And the legal fees for that, on average, were about $1 million per case as well. But moving beyond economic cases, as this panel was meant to, I think I just wanted to touch on 2 case studies. So of course one is very well known. In Peru, an investigative journalist, Paula Ugans, has been facing a number of, a range of judicial harassment, or SLAPPs as we call them more in Europe. And these were in relation to her reports on sexual abuse in a Peruvian religious association. A number of these have actually been acquitted or they've been dropped, but her case is a really clear example where the damage has effectively been done. It was kind of now allegedly, kind of now widely known as a smear campaign. But she has faced kind of a lot of the challenges that Tim was just discussing in the panel beforehand in terms of struggling to get work and increase in insurance rates. The kind of final example we wanted to touch on it was in Thailand, where a business has been targeting kind of human rights defenders, activists, migrant workers, journalists and academics for following the exploitative working conditions that they have in a poultry farm. So I think that one is quite a useful case example to finish on, because I think draws together 2 points made for both the panelists in terms of it being important for a range of actors in society as well. So as I mentioned, happy to talk further about any of the examples, but I'll pause there. Thanks, Nick.
Thank you so much. And the Gazette of Abortia case is quite interesting. I remember speaking to the editor there and about this half-baked idea I had about wallpapering an art gallery with beagle letters to show the sheer scale and the complexity of these. And he showed me this photo, and it was just box upon box upon box upon box.
Yep.
And he suggested you could wallpaper just on the legal cases that they themselves are fighting, not even going to other institutions as well, to sort of show the scale of it. And I will say, I mean, the move against decriminalising defamation is a very sombering read in the report, and sort of shows that we can't take progress for granted, and we may need to keep constantly returning to fights that we hoped we had won. So thank you so much, Elise. And I'm going to pass on to Saba. And I mean, obviously, Media Defence have been doing some remarkable work, sort of defending cases, documenting cases around the globe, you know, and showing the sort of scale and complexity of tactics, the different sort of actors behind them. So Saba, I'm going to pass on to you if you can sort of talk about your work and some of your experiences within the media freedom space. I hope you can hear us okay.
Thanks so much, Nick. Hopefully you can hear me too.
Yeah, perfect.
Great. Thanks so much. And it's a really interesting discussion. It's great to hear other perspectives on this topic. I think Elise talks of some of the trends globally. So hopefully I can build on some of that in my contribution today. As you know, Media Defence has provided legal support to journalists and media outlets across the world. So we act for journalists and media outlets in legal proceedings, and we do that in courts all over the world. But today I'm going to talk about hopefully 2, potentially 3 cases coming out of Latin America and Asia, 2 of which relate to kind of financial crime and 1 that is a bit outside of that. And what we're seeing in the course of our work and in our case docket, we're seeing kind of similar issues that are coming up in all the regions that we work in. So this obviously includes the trumped up charges unrelated to journalistic reporting, where journalists and media outlets are forced to defend allegations of corruption, where the state relies on oftentimes criminal legislation relating to alleged commission of financial crime to prosecute those journalists and media outlets. So just before I kind of do a deep dive into some of the 2 or 3 cases that I'm hoping to talk about, it's worth kind of mentioning some of the cases that are before the European Court that we're representing journalists, where they've been charged on misappropriation of company funds or tax evasion, other charges that are unrelated to their journalistic work. So, for example, we recently filed a case on behalf of Nika Gravamia, a prominent Georgian journalist and leading opposition politician. He was convicted of abuse of power and sentenced to 3.5 years in prison for business decisions that he took when he was in his capacity as a director of a TV company opposing the Georgian government. So the charges related alleged misappropriation of business funds, but they were completely without merit. And that case is actually ongoing at the European Court of Human Rights. It raises some very interesting questions around Article 7 of the Convention and the use of criminal law in these types of cases. So unfortunately, as kind of Elise mentioned, the types of SLAPP cases that we're seeing do take place outside of Europe. And I'll highlight a couple of those cases now. The first concerns a media outlet of Alfaro in El Salvador. So the outlet is one of the most prominent media outlets in Central America. They've received several international awards for their investigative reporting, and they've been reporting on matters of public interest, investigating criminal organizations, investigating corruptions within various governments, and illegal practices by security forces. So in July 2020, El Salvador's Ministry of Finance launched 4 audits against Alfaro's parent company, spanning from 2014 to 2018. And a lot of the lawyers that were working on the cases mentioned that the statutory time limit that was in place for requesting such an audit had actually expired. So many of these kind of requests actually lacked any legal basis. The audit was said to be kind of this fishing expedition. The the auditor requested information well beyond the scope of the kind of the tax probe. This, for example, included asking for names and email addresses of the newspaper subscribers.
Sorry, Saba, can you still hear us? We may have lost Saba. Hopefully we'll get her back, because they're really interesting cases, and the Nika Garavmia cases in Georgia especially was really challenging, especially at this moment in Georgia, where it's an incredibly febrile civic space. It's an incredibly complex space within which journalists, civil society is working. And then you saw the threat against someone as prominent as Nika also sort of showed how we could potentially be easy to get others, and also against the backdrop of the foreign agent law that had been proposed at the same time as well. So, I mean, maybe we can hopefully connect with Saba to come back. But maybe I'll start off with some questions, and then we can jump back when Saba is reconnected. But Peter, I mean, one thing I would just want to sort of prod at is obviously you've worked both as a sort of a journalist publishing sort of regularly, sort of in a more journalistic function, but also your book. I mean, was there a different, like, did you have to approach the legal risks and the jeopardy and how you approach the topic differently when you're working in a long form with a publisher with a different legal framework, or was it much the same and you just sort of brought it across?
No, it was very hard actually. Something I discovered through the process is that a standard form book publishing contract in the UK requires the author to indemnify the publisher. So you as the author have to assure the publisher that there's no, my contract said defamatory, which was wrong. It should have said libelous really, because everything's defamatory when you're writing a book like that. And the problem then is that the publisher have the ability to settle and then claim on the contract against you. So what you have to do is secure libel insurance in your own right to protect against that, and that's really hard. And my first quote for libel insurance for Show Me the Bodies was £25,000, which, you know, I don't know if there's any people involved in publishing in the room, but you're going to make something like 2% of that probably from the book. So in the end, we found a broker who gave a much more competitive quote, and we were able to publish it. But if we hadn't, that book would have never seen the light of day. And that's a real problem, because there's lots of good books that could be written out there where authors just won't have the means, or they won't realise that they're quite what they're indemnifying their publisher for until the legal letters start landing, and at that point they'll lose their livelihood and their home.
Yeah, and we've heard it again with I think Sam McBride talked about this in his book on the Cash scandal. But it also sort of breaks down that idea of solidarity between the publisher and the
yeah, I mean, I
writer.
should say, like, my publishers are really good. They're really nice. They work with me to find a good broker. They weren't doing anything underhand. That is the standard form industry contract. We work together to solve that problem. But it is a problem that authors who you know are starting out first time like I was might not be able to overcome.
Yeah, I mean it's really great that your publisher, but that was supportive, but it sort of automatically sets up that sort of, and you need to know that when they're not under arguably a contractual obligation to step in, but there is that broader responsibility, and it's really good that you did, but maybe it's not given, and that's something that I think publishers, and obviously Tom talks about HarperCollins' sort of very proactive, very robust defense of his book, and Catherine Belton's as well, which was really important. Saba, are you back with us?
Hopefully you can still hear me. I'm not sure what happened.
Oh, yes, we can hear you. So if you could just continue from where you left off, if possible, that'd be really helpful. Thank you.
Great. I'm not sure where I got up to, but I was talking about Alfaro and the fact that they were subject to various kind of audit requirements. I guess just to kind of round up on that case, it's worth kind of noting that whilst Alfaro was successful in kind of getting the Supreme Court to approve precautionary measures prohibiting the Ministry of Finance from requesting all this kind of excessive information unrelated to the tax audits, the substantive outcome of the audit investigation noted that they were guilty of tax evasion. That is gone through various kind of levels at the domestic court, and it kind of just demonstrates the broad lengths the government is going through, and the use of these kind of measures to stop reporting. With Alfaro journalists, it's, you know, they've been subject to Pegasus spyware. It's been a whole host of kind of targeted attacks against not only the journalists but the outlet itself. And one of the kind of consequences of Alfaro losing this case is that the government would certainly request the payment of the penalty imposed through taking control of Alfaro's bank account for that purposes. And that obviously is going to be devastating for the outlet itself. Earlier this year, Alfaro actually, who's kind of based in El Salvador, had made this decision to register as a non-profit in Costa Rica. So whilst they've maintained they're going to continue doing journalism within El Salvador, the main newsroom will stay there. The administrative and the legal operations has now been moved to Costa Rica. I'm going to just kind of talk to a second case, which kind of is slightly different, but it goes to the heart of trying to suppress public interest reporting and, you know, the measures states will go to in terms of suppressing the defense of an individual reporting in the public interest. And that's the case in relation to Trong Doi Nhat, who is a Vietnamese citizen journalist and had been very outspoken and critical of government policy. Media Defence represented Mr. Nhat and submitted a petition to the UN Working Group on arbitrary detention after he was detained in Thailand. He was effectively snatched in Thailand and then kind of handed over to the Vietnamese authority. Just to kind of give some context and background of that case, at the end of 2018 and the start of 2019, Mr. Nhat wrote a number of articles critical of the government. And as a result, he was subject to increased surveillance and received information that he was going to be likely arrested again. After the police continued with the surveillance on him and his home, he actually left Vietnam and crossed over to Thailand. And he, upon arrival to Thailand, he went to the UN Bangkok branch of the UN High Commissioner's Office for Refugees to apply for refugee status. And it was actually the following day he was kind of snatched, detained by Thai officials, disappeared. And it was sometime, you know, a couple of months later that a member of Mr. Nhat's family were contacted and informed that he was being held in a prison in Vietnam. And this kind of pattern of rendition across Southeast Asia, where states would send each other dissidents back to the state where they were wanted, is something that we were seeing. Related to Mr. Nhat's case, it's worth kind of pointing out that in July 2019, Mr. Nhat's lawyer, who was working on the defense during his pretrial detention, was actually subject to a raid at his home and office address, and key documents were seized by the police. According to the authorities, this was on an unrelated, air quotes, tax matter, where authorities presented a search warrant for the allegations. The lawyer for Mr. Nhat, Tran Vu Hai, had, you know, according to online reports, has defended other very sensitive cases in Vietnam, including other political figures, and has kind of been involved in litigation in relation to kind of conflicts over land use. He was consequently denied the request to defend Mr. Nhat. And as a result, Mr. Nhat was forced to appoint a different lawyer. The lawyer in the case, Mr. Hai, in November 2019, was eventually kind of sentenced to 12 to 15 months of house arrest for tax evasion. So Mr. Nhat's story of just kind of being snatched in a foreign country and then kind of handed back to Vietnamese authorities is terrifying enough. But this is kind of an example of a SLAPP used at one removed from the journalist against his lawyer to prevent him from providing a defense, which is it's a very scary thought that's going on, and unfortunately probably one that's not isolated, or you know, it's something that's happening. I guess if I've got time, I'm just going to talk about one last case, which doesn't kind of relate to financial crime specifically, but it's worth kind of mentioning to highlight the lengths public officials will go to initiate lawsuits against those that are reporting on corruption. And that's the case of Rubens Valente, who's an investigative reporter and an author in Brazil. So very briefly, in 2014, Mr. Valente published a book which investigates the operations of the Brazilian federal police against state corruption and laundering of public funds. The book attempted to expose the corruption, and it was kind of focused on one banker who was accused of financial corruption and attempted bribery. So despite this banker being arrested more than once for his involvement, he was released by the order of a Supreme Court judge. And Rubens Valente actually tried to interview that judge, as part of the book for a year prior to publication, but received no reply. So following publication of his book, the Supreme Court judge actually filed a suit against Rubens Valente, claiming quite high damages. And whilst the Court of First Instance initially dismissed the case, after several appeals by the judge, the Supreme Court validated the High Court decision that both Rubens and his publisher should pay moral damages to this Supreme Court judge. Interestingly, one of the kind of orders that was made was that any new edition of the book that Rubens would be printing should now include the full judgment of this case, as well as the judge's initial application to the court. So in practical terms, this order actually meant that it would increase the number of book pages within that book by 30%. And that actually made any prospect of the book's re-edition economically unviable. It obviously violated Rubens' intellectual property rights, as well as his right to freedom of expression. So I guess that case really just kind of highlights some of the kind of orders that are being put through the judicial process to and ones that journalists or media outlets are having to kind of adhere to, and the effects that's having on their kind of reporting, publishing, authoring of work that they're doing. It's actually very frightening. I'm happy to speak about any of those cases, but I'll kind of stop there and kind of pass back over to you.
Thank you, Saba. And I'm going to ask a few questions. I'm not going to lie, I have totally forgotten what time this session's meant to finish. So I'm going 15 minutes. Got another 20 minutes, thank you so much. So I'm going to ask a few questions, then I'm going to come to the audience, so please start thinking about your questions. But also I want to go to Elise and then back to Saba to look at this sort of global picture, because Saba, I mean, that last case, the idea of having to publish the judgment as an economic for pressure to in itself limit publication sort of shows, and also what you were talking about, Peter, in terms of the NDAs and things like that, this sort of creativity in how you target people, and SLAPPs never stay the same, they evolve, and things like this. So that also means that we need to be as creative to counter them, whether it's legislation, regulation, and culture change, as Susan spoke about, but other tactics. And I mean, so at least first off, like from your research, have there been any really good examples of creative responses to SLAPPs that you've seen in your research? So not the bad stuff, but actually how states or professional bodies have responded that maybe we could learn from in the UK.
Yeah, sure. And so the report does cover off some kind of positive trends and also does include some recommendations, which hopefully can be kind of a springboard for these discussions. I don't think there's kind of a magic solution, unfortunately, but they do point very clearly to the need for the legislative frameworks to be creating an environment that is receptive to more protection of freedoms. So I think that's probably the key sections that you should be looking to for solutions as well. I think Don, your point around kind of using SLAPPs positively, if you can as well. I think we emphasize the need for more strategic litigation. So there is some value in kind of testing out the limits of some of these laws. And then beyond that, I think the kind of point that links to Saba's example of ELFAR around an acknowledgement from lawyers supporting in this space that it might not be kind of just legal support in the pointy ends of the SLAPP itself, but getting lawyers equipped to be involved in a lot more of the preemptive work. So helping news outlets and public kind of non-profits really shore up some of the vulnerabilities they might have, say, in data protection or privacy laws. So trying to think more around preventive measures we could look at an earlier stage. I'm always wary of saying that because the kind of very definition of SLAPPs is that it is unfounded. So whilst we hope it can mitigate some of the vulnerabilities, we're kind of conscious it's not, you know, the perfect solution. But equally going far beyond the SLAPPs. So again, the El Faro case is an example where they then needed to relocate a lot of their governance and framework. And so getting lawyers involved at that stage as well. So the kind of corporate advisory work, which is actually a lot of the work that Trust Law, the foundation offers is kind of facilitating connections between outlets and non-profits to help with, say, getting registered, getting, you know, the appropriate structure in place, the governance arrangements and the employment law system. So equipping them to make sure that they're kind of able to still sustain their business after a SLAPP. So I'm conscious I haven't given a magic solution, but I think it's kind of a combination of continuing the legislative initiatives, getting more lawyers involved and equipped with the wide variety of legal issues and kind of areas that are coming up in this space. And then, of course, the ongoing kind of awareness raising and spotlighting some of these cases globally to see that we are learning from each of these examples.
Thank you. I think a friend of the coalition, Doug Voorhoef, has talked about needing to develop strategic litigation for public participation. Yep. Doesn't have a snap. Doesn't really
roll
work,
off the tongue,
but
yeah.
it's quite a compelling idea. Saba, as well, just the same question to you, really, like from Media Defence's work. Have you seen any really creative ways that other states have responded or non-state actors have responded that we could learn from in the UK?
Thanks, Nick. I think it's hard. One of the things that we kind of came across, or we've, and I don't have the specific case, but I think someone in the state of Brazil actually counterclaimed, so they sued them back for harassment and actually won damages, which was, you know, something that can be done if you have the means to be able to do it. But of course, SLAPPs is about money and kind of draining someone of money and resources. So I'm not sure how attractive that might be in the UK context, especially where costs are quite high. But that, in terms of other regions and other kind of states, we have seen examples of that, and that seemed to be worked quite well and seemed to be quite attractive if the framework and the kind of the cost framework works in your favor as kind of, you know, pushing back against the bully. But again, yeah, I'm not sure whether that's something that could be done as effectively within Europe or especially in the UK, given the problems that we have at the moment with costs.
Yeah, sort of the hallowed ground of slapback. But as you say, when the system itself is so structured around high costs, being able to access legal expertise and then going again into that sort of time-intensive process can put a lot of people off. I'm going to ask a question to Don, and then I may start turning to the audience. Obviously, Don, you're an activist, not necessarily a journalist, but as you mentioned, you've worked very closely with journalists. And you know, whether there's this broader conversation about injuncting you to sort of break down that media ecosystem. So if you can't target the journalist, you target where the journalist gets their information from. I mean, has this affected or your the media's willingness to work with you, or the media's sort of comfort in opening themselves up? Do you know whether journalists themselves have faced threats? Like, how does this work in the broader media ecosystem that you work in?
Well, certainly in the latest case with Bakkafrost, the injunction, the writ names a journalist, Vicky Allen from the Herald newspaper. So when we started secret filming this year, I put an invitation out to journalists. A lot of them were scared off. You know, journalists from Financial Times wanted to come, but the editor didn't allow it. So there was a chilling effect of associating with secret covert surveillance, which probably goes for filming inside chicken farms and other industries as well, not just salmon farms. But Vicky Allen was a journalist who came out, so she's actually named in the legal document for Bakkafrost. So I think there's definitely an overlap. I've given stories to journalists on a plate through Freedom of Information, so they've got the information that they can see, and then in the same way we give footage. So I've pitched a dozen stories this year based on surveillance inside farms. So there's definitely an overlap between my role as an activist, as a quasi-journalist. I'm reporting in the same way as in the good old days. There were investigative journalists who went out there and got stories. There were investigative journalists that did it themselves. They seem to be a dying breed. But I think this case, which is ongoing, if it opens it up to journalists, then we might find that newspapers and journalists have been threatened in the same way I have, and I think this feeds into the tip of the iceberg. You know, how far does this go? I know friends and colleagues who have been threatened in similar ways. Their cases haven't been publicised, but maybe journalists are being silenced and muzzled as well.
Yeah, and then there's also the idea that if there is a social stigma about threatening journalists, if a company realizes there may be reputational damage to be looking like you're targeting journalists, there may not be the same stigma against targeting activists, and maybe that's also a way that they can approach it. I mean, Peter, just one last question before I go to the audience. So I keep delaying the audience questions, but just giving you more time to think of questions. So I've got very high expectations on the questions. Is obviously you're obviously a journalist who's working in the housing space, but also a lot of people who speak out about housing don't have that background. You know, you're talking about residents, tenant groups. You know, I've spoken to, say, for example, like Living Rent in Scotland. You know, these sort of bodies who don't have that background of maybe not expecting legal pushback, but legal pushback being part of the space that you operate in. What response do you think is needed to ensure that they are able to communicate, raise concerns to their landlord or MP or councillor or a journalist? Because obviously a lot of this has been talked about journalism, but there is more and more increasing threats, and as you were mentioning, individuals being threatened. What needs to be done to protect those people? You know, how can we make sure that they can express themselves, but while not opening themselves up to legal jeopardy?
It's a really difficult question. I think people in that position there's two sort of negative implications for them. I mean, one is that you know, the sudden appearance of a legal letter is so intimidating that they just stop. And I know people who that's happened to. They just completely pull back and they no longer involve themselves in the debate, not just about this issue that they've been slapped on, but anything. And I think there's other people where it kind of goes the other way, and they sort of think, well, what the hell, I live in a country with freedom of expression. I'm going to be very gung-ho and I'm just going to carry on. And then they get, because they don't. And so they don't realise that actually this threat is actually pretty serious and could cost them dearly. And, you know, I don't really know what the answer to that is. I think, to be honest, actually, what I would say an answer to that is, I think in terms of making this a political issue, in terms of getting legislative change, I think that maybe the sort of conversation about journalists, we don't have a great reputation as a profession, sometimes fairly, is maybe the wrong way to go about it. And it's talking about people like that, people like Nina, who's going to speak later, and just the general public need to realise that they can't criticise people that they want to criticise necessarily without the potential threat of legal action. And I think you'd see much more of a kind of, you know, freedom of speech is a very kind of hot idea in politics at the moment, you know, often for the wrong reasons. But if people understood that their freedom of speech could actually be threatened as individuals, they might be much more interested in this as an issue and a campaign and something that they want politicians to address. And so I think that communicating that to people is going to help them deal with the threats if they ever do land, but it's also going to help the campaign politically to sort of gain traction and gain the attention of just voters who are not journalists and who don't necessarily like us.
Thank you. And I think we've worked with people who their first engagement with any lawyer has been to defend a SLAPP action. My colleague Jess mentioned the idea of publishing a review and then receiving a legal letter from publishing a review on a service. You know, these are people who this is not, they were just reporting on a service they provided and now are having to navigate this incredibly complex space. And you get people who, as you say, either have stepped back, deleted, just not wanting to engage, or there's that sort of almost like a fatalist running into the headlights, which I understand, but without there being protections, without there being a law that they can depend on that they believe has their right for expression, 5 minutes, oh damn, is a problem. So I'm going to go to questions. I'm going to take these two at the same time, these three at the same time. So the woman in white, the man over there with the blue tie, and this person on the front. And apologies for my descriptive skills.
Thanks very much to everyone for sharing those examples. I wanted to ask Peter about the relationship between your work and the book you've written and the Grenfell inquiry, and whether you could comment at all about whether you see any particular merits to public inquiries as a sort of form of accountability, or whether there are other routes to get accountability beyond journalism that could be useful in the kind of context of the things you're looking at.
Okay, excellent, thank you. And so yes, the gentleman over here. Because of my shoddy time management, you're going to have very short answers, I'm afraid.
I'm not a journalist, but I'm a lawyer, since you've been talking about the lawyers all the time. However, I am now subject to investigation by the Solicitor's regulation authorities for exercising my freedom of speech. So some group who have been so-called offended by my comments on the social media reported me to the Solicitor's regulation authority. It's not only me, there are apparently 50 lawyers are under investigation by the same group who are attacking me through the Solicitor Regulation Authority. So I have no fear, because I have been defender of all oppressed people, as well as allegation of crime against these people. Now, there is no question here, just a comment. The question is, I'm surprised there is no mention of the Turkish journalists who have been subjected to imprisonment, fines, and threat, physical violence by the government and their hitman.
Yes, I mean, the threats against journalists in Turkey are still the #1 jailer of journalists. They also abuse Interpol extradition requests to get to journalists who they say have broken the law, but it's just because they've been critical journalists. So it is an incredibly sensitive and important topic. But yes, thank you for that.
Yeah, I'm Andy Parsons from Protect the Whistleblowing Charity. I was just going to ask, from a whistleblowing point of view, whether the legal threats to journalists and activists either act as like a lightning conductor for whistleblowers to come forward to you with concerns, or whether it actually is another sort of arm of this sort of intimidating act by corrupt individuals and companies.
Okay, so Peter, if you would like to take the first question about the role of inquiries and their efficacy in holding power to account.
From the perspective of getting the information out into the public domain, absolutely vital. The two things that the public inquiry did with Grenfell is, one, people who would never have answered my questions were made to answer questions. I don't have any legal standing to ask questions of organisations like Kingspan and Alconic. I can ask their very expensive media teams who will then provide me a very carefully prepared statement, and that's it. The second one is privilege. The documentation evidence around the inquiry has been placed into the public domain. That attracts legal privilege. The questions that were asked and answered, the statements that the lawyers for the community made. For example, one of the lawyers in the opening section of one of the bits of the inquiry called some of the corporations crooks and killers. Now, I could repeat that in my book. It's a subheading. If I'd have put that in my book without that level of privilege, I wouldn't probably be talking to you now, because I'd be fighting a libel case somewhere. So it created privilege, it put documentation into the public domain, it asked questions. Now, the problem is that's very good, but it has come at an enormous cost in terms of the time, slowing down the criminal prosecutions. I don't know really where I stand, given that we're going to be 7 years post-Grenfell before the report comes out, about whether that was the right approach or not. But just from a purely, in answer to your question, did it help get that stuff into the public domain and help deal with the legal risk of reporting on it? I could never have written the book I wrote without it.
Thank you. I think that last question I'll open up to the panel, but maybe start with Don.
Just quick answer, yes is the answer. I've been flooded with information from whistleblowers. I got 399 documents in May. I published it with the Sunday Post, Mary Leaks, and I've got more. So yes, I think some people are silenced, but some other people are pissed off, fished off at the silencing of me. So it has the opposite effect. And that's what I was trying to get at the maybe positive aspects of SLAPPs, because I think a company shoots itself in the foot. It puts itself out there when it files a SLAPP suit, and it's a target on its back.
Okay, I've only got 2 minutes, so I'm going to pass that to Elise and then Saba. Or if it's not necessarily directed to that question, some final comments.
Only to reiterate, in agreement as well, but also wanted to say, similar to what you said, Nick, absolutely, I think Turkey has so many examples, and we've definitely covered some in our report as well. So only to say that we spotlighted a couple, but include some in there as well. Yep. So different report, but I think that also covers, and I was going to say, but we absolutely would include Turkey. And I think actually your explanation, I think, pointed to one of the most compelling things, that, of course, we're just talking about the legal threats, but not able to separate it from the physical threats, online harassment, and needs to be treated in its entirety. And on the legal threats to lawyers representing journalists as well, just to say that that's another area that the Foundation and a number of other legal network for journalists at risk partners are keen to build evidence on that too, and we're currently collecting case studies on exactly that as well. So just a call for any contributions on that topic too.
Thank you, Elise. And Saba, leave you the last word.
Thanks so much, Nick. I think everyone's covered everything. I think there's a very helpful discussion to hear from everyone's perspective. Just very quickly on the whistleblower thing, for anyone that is interested, there was a very interesting Grand Chamber decision that came out of the European Court, which actually reversed the lower chamber's finding as to what criteria should be developed for individuals disclosing confidential information, and whether that should be they could rely upon the protections of Article 10. So for whistleblowers, that's a useful one to kind of look into, and it was a recent decision that came out. But yeah, happy to kind of talk about this until what's the phrase, cows come home, but I think we're out of time.
Thank you so much. And we've actually ended on a positive note. That's terrifying. So I'm going to do it there. I'm going to stop it there because that's actually surprising. So I'll just ask you to join me in thanking our panel, both here and online. So thank you.